If in fact you married your husband and your husband owned a house when you all got married, owned his property, his bank accounts and all that when you got married, but y'all got married, you love each other, you moved into his property. Y'all been living together for 20 years now. Okay, now, you should have made sure, if you understood the law, that that man puts your name on the deed to that separate property. But if he did not do that, and you all are married now 20 years, and then all of a sudden your husband dies. Well, when your husband dies, you need to understand this with gravity, even though he be your husband, that his separate property belongs to his children. That's not even a usufruct to you. It all belongs to his children. And so those children can very much so come to you after 20 years of being married to their dad and say to you, you need to get out of our house.
It's time to really look into your retirement, how sound are your finances or your business finances. How do you start with wealth building? If these are questions you have unanswered, then welcome to Business Builders with Robert Tanner Jr.
Well, good morning, and this is Robert Tanner, and you're listening to Business Builders, and I am glad to be with you again. And I can tell you this, you've tuned into the right show. We're going to help you with a lot of information today on helping you understand what the laws are related to you planning your estate. As part of you planning to be wealthy, you got to make sure your estate is in order. So let's just get right into it. For those of you all who are listening here in Louisiana, let me give you the number right up front because you're going to probably want to use it almost immediately. You're going to be calling 504-341-8255. That's the number to call into the station. Now, I'm also going to tell you if you need to call our company, that number is 504-799-2210 in New Orleans. And if you're in the river parishes, you'll be calling 985-224-1129. Now, let's just get down to talking about all that is involved in estate planning, and I'm going to take it to the personal level because I think there's so much misunderstanding in this area. So I want to talk particularly, first of all, for you all who are in Louisiana. I want to make sure that you understand the difference in our laws and why things that you hear across the country will not apply to you. So let's just get right into it. We are under something called French Napoleonic Code. Now, what is it about? What does it come from? Well, because of how the Louisiana was settled, and because it was a oil-rich area, and parents back in the early times were becoming wealthy in dealing in the oil business, so wealthy that when they used to hold over their children's head that if you didn't do what I want you to do or become what I want you to become, then you would not inherit. And so then when the children got old enough to become of power politically, they then put laws on the books that now establish our French Napoleonic Code. Now, these laws were designed mostly and particularly, these laws were to bring about a situation where you could not now disinherit your children. And so for a long time then, when people would gain wealth, they would have to have the wealth go to children because laws were on the books that said they could not disinherit them. That's where we get this whole idea of forced heirship. And so now we have this issue of forced heirship because of those laws way back then. Now, over the years, there's been some work with forced heirship where now you need to know this if you're in Louisiana, that any child that you have that is under 24 years old is a forced heir. That means that no matter what their habit is, no matter what they do, if you try to write a will that will try to disinherit that child and you die and that child is under 24 years old, it will not work. Your will be declared invalid because that child is a forced heir. That means they must receive an inheritance from you under Louisiana law. What you also need to appreciate, and please make a note of this, if you are taking care of anyone who is a special needs child or someone who's in your house, no matter if they're 57 or 67, if they're a special needs person receiving aid from the government and you are providing care as their guardian, as their overseer, and you die while they're in your care, that person is also a forced heir. So any special needs child of any age is a forced heir, as well as anybody under 24 years old that's healthy is a forced heir. And any will that you try to write that's going to try to eliminate that person as a forced heir. And I've heard people say, all you got to do then, if you know that little Mikey or who has this special need, if you know you can't leave anything, then when you write your will, just don't write it to leaving him anything, and that way he'll be fine. That is not true. If you try to write a will that leaves him out under forced heirship laws, he will be forced to receive a portion. Now, what's the problem with that? And that's why many of you listening to me, if you have this situation, you got a child of autism or anything else that's receiving any kind of government help and they're in your care, listen to me carefully. You need as soon as possible something called a special needs trust. And you can call our office, our legal team can set that up for you, but you need to get that done. And here's why. Because what will happen is Louisiana puts you in a very particular catch-22. And here's what I mean. You're forced to leave the child something because they're forced heir. However, Louisiana law has something on the books that says that they are part of the federal government recovery program. Now, what does that mean? Because you never heard of it. Well, what that basically means is that every state that signs on to receive government benefit by way of Medicare or Medicaid or any SSI aid to a person in that state must also agree that when there's an opportunity to allow the government to recover. So what does this mean? It means then that while you think that SSI and Medicare, Medicaid are benefits to you, and in some ways they are, what you need to also appreciate as the federal government thinks about it, it's more like a long-term loan, one they're not trying to collect upon until such time as you inherit. Now in Louisiana, because you are a forced heir, because you're going to inherit, because you're forced to do so. Well, here's what happens. When you get the money from inheritance, and let's say you're that 57-year-old person in a wheelchair that was cared for someone who recently died. When you get the inheritance that you're forced to get, it now must be written straight over to the government. You have only two choices. You either one, you write the entire amount over to the government, or number two, what you do is you say, okay, I'm taking the inheritance, and the government says, fine, and we're going to stop all your benefits. Now, let me explain to all of you out here why, even if it's $100,000, why it's not worth it. You will send the money to the government. You have 9 months to do it, and you need to do that. And I'm going to tell you why it's important. Because even though you think $100,000 is a lot of money, if you have someone in your care that's getting 24-hour care by professionals, either coming into your home or at a facility where he's being cared about, $100,000 will be gone in a month. It's just not as much money as you think it is when you talk about the full-time care of someone. And Louisiana law puts you in that position. And the only way out of it is to have a special needs trust, period. There is no other way out of it. And so if you find yourself in that position, you have got to get your hands on a special needs trust. Why does that work? Because whatever was going to be an inheritance of that person, when you have a trust now, you now destroy the bloodline. The bloodline takes you out of the Napoleonic Code. And so if you have no bloodline, then you're not under Napoleonic Code law. So now the trust can receive money that would have gone to Michael, and then the trustee inside of that will have special instructions that basically say, if Michael needs a new coat, you're not going to ever go give Michael money for a coat. You're going to buy the coat, and then you're going to bring it to the facility where Michael is. And because of that, Michael still gets his benefits for the rest of his life, and you still have control over the money that would have messed up his entire estate and would have messed up that entire process. And the only way to accomplish that was a special needs trust. So I hope you're listening to me about that. Now, some other things I need to tell you about Louisiana law. This is the worst state in the union to live shacked up. It is the absolute worst state in all states to be shacked up. Now, let me tell you why this is so important. And I know you may give me many reasons for it because, we get Social Security. I don't want to mess up my Social Security. I don't want to mess up his. And we're older. We know better. But we're living together. We're not trying to mess up our money. Listen to me carefully. Now, here's what happens in this state so you understand what's going on. In this state, a man's children is his bloodline. A man's wife is not. And I want you to hear me really well. Even though I may have had the children with my wife is not considered my bloodline. My children are. Now, Louisiana law is very particular here because it talks about that the things follow the bloodline. And so if you are a wife, I want you to understand what's happened. In Louisiana, you've probably heard this French word called usufruct. It basically means that you get to use things that don't belong to you. And you allow this use as long as you don't do something ridiculous. So let's just talk about what that would be. So I die. Here's what they're saying. When I die, half of my estate belongs to my children, period. There's nothing can stop it. It belongs to my children. And then the other half, my wife gets something called a usufruct. Now, what does that mean? It means she gets to use the house. It means she gets to use the things that I left behind, understanding that they ultimately belong to the children. And so usufruct keeps them from kicking her out of the house. Usufruct keeps them from taking things from her, but she needs to understand she's living in their property. Now, what does that mean? Let's take it one step further. It would mean, and she would find out what it means, because if she were to try to sell that property, she would need all of my children to sign agreeing to that sale. If she were going to make a loan against that property, she would need all of my children to sign agreeing to make the loan. And so what she needs to understand, she has usufruct. She gets to use it. She gets to live there. But if she were to try to change title, try to transfer, try to make a loan, anything like that, she would come to find out that she doesn't really own it like she thought she did. Now, a lot of people think that, well, you know what I'll do? In my will, I'm going to will my property to my wife. And why that sounds good, remember what I told you at the beginning of the show. If that child, if any of your children at that time are under 24 years old, or let's say one of your children died and his child is under 24 years old, and if that were to happen, your will would still have a problem because there's a forced heir in the group that is forced to receive their share. So even though your will said, I'm giving it all to my wife, if your will was written against the law, your will is invalid. And so this opens up a can of worms that you're not even ready for. And so you need proper counsel here. You need someone who knows what they're doing to put the proper kind of paperwork in place, because what you think is going to happen is not what really is going to happen. And the succession laws in this state are very specific. The succession laws in this state are very point on about what goes on here. And the judges understand the law. And many of us, when we don't learn the law until we're in court. And so we're trying to help you get ahead of this so you understand exactly what's going to be going on. So here's the thing. Under Louisiana succession, wives, all of you listen to me. Here's how it works. If you are in community property, meaning since you got married, everything you acquired together. In other words, you did not come to the marriage with separate property. He did not come to the marriage with separate property. Everything you all have, including your first house, came in your community. Now, let's just say that's what the situation is. Now, you have children that are growing up, and we hope that no one would die before those children were grown. Okay, now, but if your children are grown and you don't have a will, at least a will, then that would mean then that when you die intestate. So even though the forced heir laws should not apply to you, they will apply to you because you didn't do a will. So now your children, even though they're not they're all over 24 years old, even though they're all 30, 40, 50 years old, they now are in line again to be heirs. So that same usufruct thing we said before works. Now, this is community property. So in community property, spouse, wife, listen to me. In community property, you are in a position where you get use of the things at the death of your spouse. Now, what I need you to appreciate now is that's different when it comes to separate property. So let me talk about separate property for a moment. If, in fact, you married your husband and your husband owned a house when you all got married, owned his property, his bank accounts and all that when you got married, but y'all got married, you love each other, you moved into his property. Y'all have been living together for 20 years now. Okay, now, you should have made sure, if you understood the law, that man puts your name on the deed to that separate property. But if he did not do that, and you all are married now 20 years, and then all of a sudden your husband dies. Well, when your husband dies, you need to understand this with gravity, even though he be your husband, that his separate property belongs to his children. There's not even a usufruct to you. It all belongs to his children. And so those children can very much so come to you after 20 years of being married to their dad and say to you, you need to get out of our house. and you would not have a leg to stand on. It wouldn't matter if you cooked meals for 20 years. It would not matter if you bought the furniture and put it in the house. None of that would matter, because it's his separate property, and his separate property belongs to his bloodline. His bloodline is his children. And so if you are one of these people who are now the stepmothers to some children, and you've moved in and are living in separate property, you've got to get with someone to make sure your rights are protected. Now, if you live in another state besides Louisiana, if you lived in Tennessee, for example, after you live together for a certain period of time, you would earn something called dowry rights. You would have about 40% after 10 years of actual ownership right. But that's in Tennessee. That's not here in Louisiana. In Louisiana, as I told you earlier, if you're shacking up, you get nothing. I don't care how you say it. You can call yourself the man's last name. You can do what you want to do. If that man does not marry you and then make you part of his separate property and then enjoy the community property together, I'm telling you that you will be in a really bad place if something were to happen to him. Now, what else is separate property? Along the way in a marriage, we inherit things. People die and they leave things to us. Anything that you inherit is your separate property. So anything you inherit from your family is separate property. However, it would not be separate property unless it's maintained as separate property. So for an example, if you were in fact to get a situation where, let's say your dad left you $100,000. He died and they give you a check. The lawyer gives you a check for $100,000. Well, right now it's your separate property. Now, to keep it separate, you would have to go open a bank account with just your name on it. Let the $100,000 go into that bank account, and only you would access it and use it as necessary to keep it as separate property. But if you were to take that $100,000 that was separate property when you got the check and bring it to a joint owned account owned by you and your spouse and deposit it in that joint owned account, then what was separate property has now just become community property. Now, that's important because if someone was thinking about divorcing you, then that would be a perfect time to do so after you just put a large deposit into a joint account. So what you want to be thinking about, and why you have to know these laws and understand these things, is so you don't make mistakes, so you don't do the things that will hurt you as it relates to your estate. And so if you don't know better, you can't do better. So this is about today helping you to understand how it works. Now, even if you are a spouse, when it comes to separate property, where are you in line? Well, I want you to know you're in the 8th position to receive. So I want you to hear me carefully. In the 8th position to receive. So unless your name is put on property by act of donation or done on purpose, it's not likely you're going to receive, because the first place it would go would be to his children. In absence of his children, his grandchildren. In absence of his grandchildren, his brothers and sisters. In absence of his brothers and sisters, his uncles and aunts. After his uncles and aunts, his nieces and nephews. After his nieces and nephews, then his parents. After his parents, then the spouse. So if it's separate property and you think you're going to receive it, you need to really make sure that your name has been somehow put on that separate property, or you're going to be shocked to find out that you're not even anywhere close to receiving any of that property. So one of the biggest reasons we encourage you, if you're going to live together, to get married, is because at least you could have some community property rights over the things that you have come across together. And if you're marrying someone who already has separate property and you want to protect your rights, then that person has to do one of two things. Either number one, put your name on all the separate property legally, or number two, do a trust and put all the property in a trust and then name you as a co-trustee. Those are your options. Beyond that, there is no option. So you have to be very cognizant of how these laws affect you and what you have to do about that. Now, if you have any questions about any of this, you can give us a call. The number is 504-341-8255. We'll be glad to answer your specific question. But just want you to know where we are so far is helping you to understand what your rights are under law, especially in a Napoleonic state like we're in, and especially when you're under the laws that we're under, because they're different than any other laws in the nation, and that's why you have to understand them. And it is critically important that that you understand it, because to fail to understand this would hurt you in ways you cannot even get yourself ready for. I'm talking about devastation, because you've heard stories about children, their dad died and they put the woman that their man lived with, and you say, oh, what a shame that they put her out in the streets. You don't even get to take the furniture with you. When you get kicked out like this, you don't take nothing but you out of here. And the reason for that is because, remember, possession is 9/10 of the law. So if the furniture is sitting in the separate property that belong to the other person, then that means that the furniture is a part of the separate property, which means you get to leave with the clothes on your back. You don't get to take the couch you bought. You don't get to take the TV you bought. You don't get to take anything you bought. Now, when it comes to the bank account, you say, well, half the money in the account belongs to me. Well, not so fast. When we freeze the account and we decide how much belongs to the children, and then we'll decide how much belongs to you, and so on and so forth. That means even your own money is frozen while you're waiting on this process to see if you'll get your own money back out of the bank account. So I am telling you, this is the worst state to be shacked up in. So if the man says he loves you, stop worrying about your Social Security check and all that kind of stuff. Make the man marry you so the rights that are important to you will be upheld and you have some right when the time goes. And if the man says he loves you, or whatever the case may be, then get your name on that property you're living in. It's a simple act of donation to get it done, or get a trust done and become the co-trustee, and you will have your rights protected. But if you don't do that, you're going to be in for a very rude awakening when that time comes. So if we can help you with this, we'd like to answer any questions you may have about it. I know I've put a lot on your plate. You can give us a call. The number is 504-341-8255, and we'll be glad to do what we can to answer that question for you. Now, I need to tell you, we're going to take a break right now. We're going to be right back. And when we come back, we're going to be talking about gifting and the effects on gifting.
Integrity Financial Business and Corporate Services, an independent and business consulting firm under the leadership of CEO Robert Tanner Jr. We specialize in advanced business planning, maximizing tax reduction, redirecting strategies, and much, much more. It's time to let the professionals at Integrity Financial Business and Corporate Services lead you in the right direction. Visit us online at integrityfbc.com. Email us at info@integrityfbc.com or call to make an appointment at 985-224-1136.
Well, welcome back. I know I just gave you an earful in the first part of this show related to the laws in Louisiana, and I thought it was important to do that because if you're going to be doing wealth planning, you need to understand how these laws work and how they're going to affect what you are doing. Now we need to talk about people always think that they have a better way. They always have a shortcut or something they heard somebody do that sounds good, that sounds like it could be a great thing to do, sound like it's legal, and it's helpful to do, and so I'm going to go ahead and do that. So let's just deal with some of those, I call it Cajun finance planning, so that you understand some of the shortfalls with that. First of all, to do any kind of gifting program, I would always say you'd have to know your date of death. So the reason that most gifting programs wouldn't work for most people is because you don't know your date of death unless you have planned it and you have the fortitude to carry out suicide when the day comes. But most people don't do that or can do that. So let's talk about this idea. I've heard people say to me, yeah, Mr. Tanner, I hear what you're saying, but you know what? I'm just going to give it all to them before I die, and then it won't be a problem, right? Wrong. Let's talk about why that's wrong. First of all, when you gift your house, let's say let's give you this scenario. Old man says, hey, look, son, I'm going to go ahead and gift this house to you so that when I die, you won't have a problem. Everything will be fine and everything will be in your hands. Okay. I just want to live here until I die. Okay. That's all I want. Are we good on that? And the son says, sure, no problem at all. Now, here's what happens. Let's just say now that everybody understands the agreement. Son leaves the house. Everything is fine. The world is wonderful. Okay, now, here's the problem with this whole idea. Now, let's say the son goes out and he gets into an automobile accident and someone gets hurt very bad, and it was the son's fault. Okay, maybe a child was killed in the accident, but it was bad. Now, what happens is, it was an accident nonetheless, but this is Louisiana. You know you're getting sued. There is no getting around it. You are getting sued. Now, here's the situation now. You were at fault. So the insurance company's lawyers are going to do all they can to say, hey, Your Honor, we'll fix the car and all of that. I mean, we'll take care of that, but we're not at fault here. And his medical coverage, he had that basic Louisiana coverage that you get from these places we will let be nameless right now. So he had no medical coverage and so forth, and so he's being sued personally. Now, he goes to the court. The judge probably won't make him homeless. So the house he lives in, he'll probably get to stay in his house. Any money he gets, he probably have to pay with that. But it is now learned that he has another asset. What is that asset? It's his father's house. That's now in his name because it was gifted to him. So while the judge is not going to make him homeless in his current house, however, because he has another asset, that asset now becomes disposable to help settle this lawsuit. So now what ends up happening is he goes and he has to tell his dad the sad story. Dad, you know about the accident? Yes, I do, son. I'm glad you were okay with that. Well, Dad, it's worse. Well, what do you mean? Well, I lost and we had to settle with them. Okay, son, well, I'm sorry to hear that, but I understand. Well, no, it's worse than that. The judge ordered that I sell assets to go ahead and pay these people the money that he awarded them. Okay, but I don't know what it has to do with me. Well, the house that you gave me a year ago is considered my asset. Because of that, I have to sell the house. And then the proceeds have to be paid to those people the judge awarded. I guess in short, what I'm saying is you got to move. You got to leave. Now, had you not gifted them the house, you wouldn't have been exposed in this way. But because you did, you're exposed to those kind of actions. Now, also that you need to understand this, that when you gift a house to your son, when you gift while your son is married, you're gifting it into his community. It's not like inheritance that will go just to him. So even though you gifted just in his name, you gifted it to him while he was married in a community property state. Now what that means is now if his wife now divorced him after he's received the gift, then that means now that's an asset of his in the community, which means that asset now has to be divided in half and she has to get her share. So if your house was worth $200,000, for example, and now she divorces him, then the house has to be sold or a loan got to be put against the house that gets $100,000 to her as part of her divorce settlement. Why? Because you gifted when you shouldn't have. And so all these people who think they're smarter than the law, who think I'm just going to gift it to my children, I'm going to avoid all of this, you need to understand you're exposed in the worst possible way you could be exposed. Any kind of lawsuit action, any kind of divorce action, anything that comes against them will affect this gift that you tried to give to them while you thought you were making it easy because somebody told you that all you got to do is gift it to them ahead of schedule.
Integrity Financial Business and Corporate Services, an independent and business consulting firm under the leadership of CEO Robert Tanner Jr. We specialize in advanced business planning, maximizing tax reduction, redirecting strategies, and much, much more. It's time to let the professionals at Integrity Financial Business and Corporate Services lead you in the right direction. Visit us online at integrityfbc.com. Email us at info@integrityfbc.com or call to make an appointment at 985-224-1136.